Well, good afternoon, everyone, and thank you for joining us. And welcome to the Caregiver Coalition monthly webinar. Today is the first time in a while that we've had a webinar at noon, so it looks like we have a pretty good attendance around this time. I'm Matthew Parcasio. I'm the Caregiver Programs and Outreach Coordinator at Aging and Independent Services, a department of the County of San Diego Health and Human Services Agency. I'll be your host on behalf of Caregiver Coalition. It represents the community efforts of a diverse group of agencies, private, public, professional, nonprofit, for-profit, that serve individuals caring for their loved ones. Our collective mission is one of support, education, and advocacy for family caregivers. I'll be recording today's webinar for future viewing. Past webinars can also be found on our Caregiver Coalition website. I'll be sure to add that into our chat. But thank you so much for joining today's webinar. We are so pleased to have attorney Richard Scott Stewart, who will be talking about planning for incapacity and how to avoid those common mistakes. So there'll be a brief time for question and answer at the end of the webinar. So if you have some questions, hold on to those questions, or you can add them into the chat and type your question in there. And if you can also kindly put yourselves on mute, so that we can assure that Scott's presentation goes smoothly. Richard Scott Stewart is an elder law attorney concentrating on Medi-Cal benefits, estate planning, and asset protection for California's older adult population. Drawing on more than 25 years of specialized legal experience, he's a longtime educator and advocate in the field, frequently presenting throughout Southern California and contributing to professional associations, caregiver organizations, and community groups. Now it's my pleasure to welcome Scott.
Thanks. That was a great summation of my bio. I should have you rewrite it for me, since that was so great. And I mean that with all sincerity, because my bio, as everyone will see here in a second, is really long. So what I'm going to do here is I've designed a PowerPoint presentation I'm going to kind of run through. I think that's an easier way to kind of look at this. So I'm going to go through that with everybody. I don't have an enormous amount of time, so I'm going to definitely ask that you kind of use the chat for questions, and we'll kind of address those questions at the end. Today's program is kind of a modification of a program that I frequently give about elder law, and Elder Law 101 is the way we often cast this. And specifically, it's about how to plan for incapacity and what that stuff entails. So today, I'm going to try to cover the following topics. I'm going to give a brief introduction. I'm going to go through some facts. Maybe we'll cover some myths and misconceptions, but we'll definitely get into the essential documents and planning for long-term care and dealing with those things. So let's first, and here's my bio. So this is why Matthew's version is so much more helpful. So I will be plunking that from him. So the way I like to think about elder law and incapacity planning and what I do, and I guess I should take a step back and say I've been doing this work for, this is my 30th year in practice. And in my practice, I represent a large number of people who are suffering from long-term disabling conditions. In fact, my practice area, my clients are disproportionately people suffering from conditions like Parkinson's and Alzheimer's disease and other conditions like that. I do characterize myself as an elder law attorney and not necessarily an estate planning attorney because, in my opinion, there's a distinction between the two things. That distinction is that elder law attorneys tend to focus more on incapacity, or what happens during your lifetime if you happen to get very sick, and then secondarily deal with the tax mitigation issues and probate avoidance issues, which are important, but I don't think necessarily as important to the general population as incapacity, and we'll talk about why that is in a second. So this is a quote from Donald Rumsfeld that I think kind of helps frame a lot of these issues, and he did get a lot of grief for this quote, but it's very accurate and very true. And it is that there are no knowns, there are things that we, and that is there are things that we know. There are known unknowns. I would say there are things that we don't know, but there are also unknown unknowns, and these are the things that we don't know. And in the world of planning, that often is what happens, is we've got all these things that are going to happen and we don't know what's coming down the pike. So how do we plan for these things that we're not even aware that they exist, and we don't necessarily even haven't thought about that. So when we're looking at this, some facts that kind of frame this issue is that currently about every 10 seconds, someone's turning 65 years of age. And by 2030, 72 million people will be over 65 years of age. That'll be okay. So we're getting a feedback that someone isn't muted. And that's roughly 20% of the population. And that becomes really important because a significant percentage of people are going to wind up needing long-term care. They're going to have an event that's going to cause them to become incapacitated either briefly or an extended period of time. And in fact, there are studies out there, and I just looked this up about 30 seconds before I got onto this call. New studies are saying that roughly 70% of people, once you hit the age of 65, are going to need some form of long-term care assistance. And that's defined as needing help with at least one activity of daily living. It doesn't mean it's permanent. It doesn't mean you're going into a nursing home or an assisted living facility. It doesn't mean that you're paying for care. It means that someone in your life is helping you meet at least one essential function, one activity of daily living. And those could be things like dressing or bathing or helping you with meal preparation or shopping or critically, medication management. And medication management often is a really complicated issue because these medication regimes that doctors put you on can be very, very complicated. So a significant portion of folks are going to need some form of assistance. But this is where the disconnect, in my opinion, really becomes important. Less than 10% of seniors have had a conversation with anyone about what those preferences are. So, and that disconnect is what I think creates an enormous problem because we have a number of people out there, again, 70% of the population are going to need some form of help, and that help is being given to them by people who don't necessarily understand what kind of help that person wants, where they want that help to occur, and then critically how to pay for it. So that disconnect is the thing that I'm trying to fix. And so my principal goal with this program is not only to kind of help folks understand all of these issues, but to invite you to have a conversation with the people that are important in your life about what those preferences are and document what those preferences are so that you can age successfully. That's my goal. That's what I hope people get out of this today. And let's get a little bit further into this. So as we look at this more, 1 in 6 are going to have some form of dementia. And then Parkinson's disease, which is a terrible disease, that has an average age of onset of 57 years of age, which is younger than most people think. This long-term care issue and incapacity issue is not necessarily just for senior citizens. 40% of long-term care services are currently used by people under 65. And if you think about that for a second, how does that happen? Well, you've got people, again, as I'm defining long-term care services, that's a period of time where you need help meeting activities of daily living. So people have strokes or heart attacks or car accidents or sporting injuries, and they need time to recover. And in those situations, long-term care services, again, are being utilized for a period of time while that person's recovering. Couple questions on this slide are about capacity and incapacity, throwing these words around. What does that mean? Well, capacity means that you understand. Okay, so I don't know why I've got a feedback loop here. So I don't want to blow everybody away by having an echo. So capacity is whether or not you have the legal capability of entering into contracts, creating documentation, documenting your wishes, participating in these conversations. The San Diego courts and the courts in general stretch to help people find capacity. And there's this concept of assisted participation, where even if you have a condition like Alzheimer's disease or dementia or some other kind of thing that might cause you to have limited might have limited capacity, they want to help people and facilitate people in documenting what their wishes are and participating in these conversations. So capacity is kind of a nebulous term, but it is important from the standpoint of it is um, it allows us to have the legal standing to involve people in that conversation and participate in those conversations. So the question becomes, who determines whether or not you're capable? And there's really three possibilities from my perspective. One is physicians, doctors, the other is lawyers, and the third is the court. In terms of determining capacity, the gold plate standard and who absolutely determines capacity is a judge. If you get taken into court through what's called a conservatorship process or some other similar process, and a judge adjudicates you to be incompetent, it doesn't matter if you're competent or not. It doesn't matter if you understand what's going on or not. That judge's determination of you being incompetent makes you that's a finding that you do not have capacity, and you won't have capacity until the judge adjudicates you to have capacity. I mean, you think about someone like Britney Spears, for example. She was determined to be incompetent for a while, and now she's competent. I'm not sure what's changed in between those times, other than the fact that a judge has said she's competent and incompetent. So, so a judge is really the only person who can determine capacity. And I know that's kind of difficult to kind of think about when you look at your trust documents or other documents, and it says two doctors, independent physicians determine whether or not I'm competent. That two doctor standard is not legally binding. It's merely evidence of your capacity. And for your legal documents, that's the triggering element. So what that says is that we need these two doctor's notes to trigger the contractual language to switch who the trustee is or to put someone else in charge of your finances. It's not a legal determination. You have the right to challenge that. It is not necessarily, it's not binding necessarily until the judge adjudicates that. Lawyers also determine capacity from the standpoint of writing documents. So if I've got clients of mine coming into my office and they are tracking what I'm talking about, they clearly understand what it is that they're trying to do. They understand what's going on with what their documents are doing. They understand the conversation I'm having, and I can determine that they have got sufficient capacity to create the documents that they want to create at that moment in time, even if they have a diagnosis of dementia, even if they have a diagnosis of early stages of Alzheimer's disease, they may still have the prerequisite legal capacity to do the things and to document what their wishes are. So capacity is really the critical element in being able to control what's going to happen during a period of illness, during a period where you need long-term care, because you've got the absolute right to participate in those decisions until you're no longer competent. So when we're dealing with long-term care issues, how does this thing get paid for? And critically, how much is the cost of care? Care costs can be incredibly expensive. And so the average cost in the state of California is about $14,000 a month. That is not the average cost in San Diego County. It's significantly higher than that, but that's what the state of California has determined is the average cost. How high can it be? Well, I've got a client of mine right now that's paying $40,000 a month for her husband to receive long-term care services in the facility where he's located. He's got some difficult situations going on, so it's particularly expensive, but that is an enormous amount of money. And how do you pay for that? Well, most people think Medicare is going to pay for their long-term care cost. It isn't set up to do that. Medicare is health insurance effectively, and it's designed to pay for acute care, which are temporary conditions that are treatable and curable, and that so if you break your hip, you have a heart attack, you've got a stroke, you have something like that, the Medicare system and whatever that supplement is will handle those types of things. But when you move away from those acute care services and into a situation where you are dealing with custodial care, where you have someone who's helping you meet your activities of daily living, Medicare isn't going to pay for those services. So if Medicare doesn't pay for it, then what do you migrate to? Well, you do what many folks do, and that is you start writing checks. You start using your money, and if your money isn't sufficient, maybe your family comes together and all comes together to support you. And that's okay, but it can be very expensive. And for folks who don't necessarily have an enormous amount of money, the prospect of paying 10, 15, $20,000 a month for long-term care costs when you're on a fixed income and have a limited amount of savings causes a great deal of financial strain and causes folks to wind up selling everything. Long-term care insurance, it's a special kind of insurance that will pay for custodial care. The problem with it is less than 10% of the senior population has it. And by the time they realize that this is a product that exists, they usually have a diagnosis that causes them to be no longer insurable because pre-existing conditions do exist. Those pre-existing condition limitations do exist in the long-term care insurance world. And then you've got other government benefits, and those typically are things like Medi-Cal here in California, Medicaid elsewhere, and VA benefits such as aid and attendance and service-connected disabilities. And certainly that's where most people eventually migrate to. In my office, we're often helping people understand what their rights are under those programs and how to qualify for those programs. That's not the purpose of today's call, but it is important when you're dealing with incapacity issues to understand how to pay for care, because if you're creating a plan to pay for care, that is a big chunk of it. Here's the care I want, and here's how I'm going to pay for it. Am I going to use my personal funds? Do I have long-term care insurance? Or am I going to migrate to some other kind of benefit program? And here's what it takes to make that stuff happen. So this, in my opinion, is an incredibly important part of that call about incapacity. And so these are your programs, Medi-Cal, and attendance. And so how do we document our wishes? How do we plan for incapacity in such a way that people understand and are bound to follow our wishes? Well, we use our estate planning documents to do just that. Most estate planning documents that I review, and I've looked at thousands of documents over my career, if not tens of thousands, those documents typically are focused on what is going to happen after you pass away, right? That tends to be the principal and the center focus of that conversation, right? Are you going to give your money to your kids outright? Or are you going to give it to your sister, the charity? What are the restrictions on all that stuff? Who's going to manage the money after you pass away? Who's going to control the distributions? What's going to happen with your house after you pass away? All of those issues tend to be what's addressed. I'm going to suggest that we need to be looking earlier and also address what happens should you become very ill. Should you be unable to manage your financial affairs anymore? Should you be unable to communicate those wishes? And the priorities of you as the individual need to be incorporated into your documents. And if they're not incorporated into your documents, then what happens? Well, your agent doesn't have a plan. They don't have a crystal ball. They don't necessarily know what's going on. They may not understand what it is that you want to have happen, and they start making decisions based upon what is the most efficient for them. What is it that they feel is the appropriate choice? And that may or may not be what you want to have happen. So I've literally had kids of clients of mine who walked in my office and say, we're moving mom or dad to Michigan because it's cheaper. And when I say, well, why Michigan? Is there any relationship to Michigan? And it's like, oh no, my cousin lives there and she's going to take care of them. They don't know anybody there. And so by moving to Michigan, we've now stripped that person away from their entire social network, all of their friends, everything, because it's cheaper. I recognize money is an important piece of this puzzle. That's why we're just talking about how to pay for care, but it's also equally as important, it may be even more important, that a person is receiving care where they want that care to be and where they have the social supports that can help them with those, making sure that they're getting the care that they're entitled to, making sure they keep the relationships that have been developed over the years, making sure that they have all that stuff. So what is it that helps you do that? Well, I see 5 essential documents or maybe 4 essential documents that will help someone to document what those wishes are. And the first document, and by far the most important document, is your advanced healthcare directive. California has a statutory form. If you Google California Advanced Healthcare Directive, you can get it off the internet for free. If you don't have access to Google and getting it off the internet for free, and you go to any healthcare provider, when you check in, they always ask you, do you have your healthcare directive? And if they don't, they give you one, right? So it is the most important document. Because what it does is it gives someone else the ability to manage your healthcare decisions. If you don't have this document, there are no defaults. So there is no automatic, my spouse is automatically in charge of my healthcare decisions, or a parent is automatically in charge of their adult child's healthcare decisions. And that's important because at 18, a child becomes an adult and the parental rights to manage their healthcare disappear. So there are no defaults. And what this advanced healthcare directive does is it gives someone not only the power to deal with end of life issues, which are very important, but they also give an individual the power to select things like who's going to be taking care of you. Are you aging in your home? Are you going into a facility? What kind of care you're receiving? Who your doctors are? What your medication is going to be? It gives an enormous amount of power to the person who's going to be taking care of you. And therefore, inside of your healthcare directive, it's important that you help define what it is that you want to have happen. Now, I'm not suggesting you put handcuffs on your caregiver or on your agent, your healthcare proxy, that they can't do, and they don't have the flexibility to manage your physical body. But I am suggesting that you help them understand what your preferences are and how you want things to be done, so that they will be able to better meet your needs and better cause you to be able to be successful in your aging process. In terms of your advanced healthcare directive, one of the biggest mistakes that I see, other than not having one, is that people fail to, that they have either one agent, so they'll name their spouse and they'll have no successor agents, and then there's potentially a vacancy, or they will name everybody at once. So you'll have co-agents. And the problem with co-agents is that there's not a clear, it's not clear who is in charge of your healthcare decisions. And if there's a conflict, there, without having specific provisions in there how to break that conflict, you can create a situation where the doctor is going to send everybody off to court to figure out who's in charge. So healthcare directive, very important for everybody over the age of 18. The HIPAA waiver is a document that gives a third party, anyone in your life, access to your medical information. HIPAA made, and the California Medical Information Act makes your medical information confidential as to all third parties. Third party is everyone other than you and the doctor. So I strongly encourage people to create standalone HIPAA waivers in which they give access to their medical information to all the people that are important in their life. And that way those people can check on them, interface with the physicians, interface with the pharmacy, interface with the care facility, and see what's going on. So I see that as very important. Third document is a financial power of attorney. That financial power of attorney is going to give someone the authority to pay your bills during your lifetime. Without a power of attorney, there's no defaults. So if, for example, I went to the bank and said, my client wants me to have access to their bank account, I don't have access to their bank account. I mean, even if I went to my parents, right? I go to my dad and my dad's bank and I say, I'm the eldest son, I want access to his bank account. The bank is not going to allow me to have access to that without a court order or a financial power of attorney. And so that financial power of attorney authorizes someone to pay your bills and manage your money in the event you can't. A will is a document that doesn't do anything for you while you're alive. It merely directs how you want your property to be distributed after you pass away. So many people think, well, I've got a will that's going to cover all this stuff. It doesn't. All it does is says, if I want my stuff to go to my kids, or I want my stuff to go to my wife or my parents or wherever it is. It clearly delineates that. If I don't have a will, and all wills go through probate, then I am using the California intestacy statute, which is the standard for what California thinks everybody wants. And so what that distribution system is effectively is things get divided amongst spouses and children, whether it's separate property or community property. It gets a little bit complicated, but it often is not what people want, and therefore people design wills to do something different. A trust is kind of like a combination of a power of attorney and a will, in that it controls what happens after you pass away, and it also allows for the management of the assets inside of the trust during your lifetime. And for folks who've got larger estates and want to avoid probate, that's where they often migrate to, is creating trusts. And trusts are very popular in California for that reason, because they're more efficient than going through the probate court, often cheaper than going through probate court, and they allow for a seamless transition of all of that of your financial affairs during your lifetime, should you become incapacitated. So trust can be an important part of this puzzle. And again, I'm not here trying to pitch any type of documents. I'm trying to explain the general nature of all this stuff. So the essential documents, again: healthcare directive, HIPAA waiver, financial power of attorney. My feeling is that if you're over the age of 18, everyone needs one of these. And then to the extent you're going to deal with incapacity issues or aging issues, you definitely want to include what your priorities are and preferences are in those documents, so that your agents understand clearly what you want to have happen. If you don't have those documents, what happens? Well, that means that you have not expressed your preferences. And if something happens, now you're getting into the world of a conservatorship. A conservatorship is what some lawyers would call a living probate. It's part of the probate process. You go to court and you're having a judge determine that someone is not competent. They can no longer manage their affairs, their physical or financial affairs. And then critically, they also do not have documentation in place giving someone else the authority to manage those issues. So a court gets involved, and a court then has to make several decisions, which can be rather expensive. The last one of these conservatorship that I kind of mediated, when we settled the issue between all the siblings, one of the lawyers walked out of the office quite distraught, and he was rather upset because he was expecting to earn about $100,000 in attorney's fees for the first year of services. They're very expensive because there's multiple trials that potentially happen inside of the first year, and there's annual reporting and. So my suggestion is for all of my clients is avoid conservatorships like the plague. They're a necessary evil. There's definitely spaces where they have to be done, but and typically that's for folks who have problems with their documents. But if we can avoid it altogether by creating the healthcare directives, the powers of attorney, and those other documents, and documenting your wishes, then you're not having the court appoint someone that they feel is appropriate for you, and you're not having the court help direct what's going on because the judge feels that whatever's appropriate for you, you yourself are controlling what's going on by the documentation that you've created, indicating what you want to happen. So conservatorships, it's a necessary evil. We want to avoid it like the plague if we can, and that's done through the documents. So what can you do now? Well, what I suggest to all my clients is go look at your documents you currently have, whether it's your healthcare directives, your trusts, or whatever it might be, and review them. Make sure they're up to date. Make sure that your agents are what you want to have happen, or who you want to be empowered to take care of what's going on with you financially or physically. If something has occurred, some medical condition, maybe marriages, divorces, deaths, you want to make sure that your agents still work. A number of years ago, there was a colleague of mine who I reviewed her documents, and they've been in place for quite some time, and she was surprised that no one had pointed out to her that the only agent on her healthcare directive was her husband, who had passed away 3 years prior to that. And if she had had a problem because there was no one in her document, we'd be going to court. We'd be dealing with the conservatorship issue. We'd be dealing with all of those things. And so making sure your agents are right is going to be really important.
Yeah,
Making sure.
this all the time. It's like straight in thing, but are they upside down?
Okay, so secondly, start reviewing what you want to have happen in terms of a care option, in terms of care options. So if you're aging at home, make sure that that's what you want to have happen. And then consider documenting those wishes and communicating those wishes to your loved ones and your agents so that they will, in fact, understand what you want to have happen. If you do all of those things, I think you're going to have a much better outcome in terms of aging successfully and planning for incapacity and dealing with incapacity if that arises. So I'm recognizing that I'm kind of at the end of my half an hour, but I will say one last piece before Matthew comes in here and gives me the hook, because I can see he wants to do that. Where do lawyers get involved in this, right? Because I'm a lawyer. Lawyers aren't necessarily smarter than you guys. What lawyers have is they've got experience and they've perhaps seen the movie before, and they can ask pointed questions. So my suggestion is, take a crack at this, put together what your plan is, and if you have a lawyer, or if you have some type of, or if you've used a lawyer in the past, bring your questions and bring your ideas to your lawyer and say, hey, this is what I kind of want to have happen. Help me document this inside of my documents. It is absolutely critical that you do not, and do not take your trust or your will, your power of attorney, and start writing all over it, because you can invalidate your document. These have formalities and the creation of them, and I don't want to have people, destroy what they have because they're trying to document their wishes. So it's important that you don't write all over your documents, and you want to maintain that formality. But it is also very important that you clearly indicate what you want to happen and communicate that with the next folks. And lawyers, they're helpful, but they're not necessarily, I'm not going to say they're not important. They're an important part of the puzzle, but we're no smarter than you guys are. We've just been snake bitten more often. I guess that's what we put it. So you guys can do this, communicate your wishes, document them, review what you have. 12:32. Thanks, Matt.
Thank you so much, Scott, for all that vital information, bringing it to light. I know we are out of time, and we could definitely go, 30 more minutes to expand more on this topic, since this has been such an important and actually interesting, because nearly over 30 people in attendance today. So, Scott, if they have any questions, would you be willing to put your email address in the chat?
Oh, yeah.
If anyone wants to specifically reach out to you.
I'll put my email address and my phone number in the chat. So my email address is, and my preference would be, my email address is scott@estate-autolaw. My phone number is 619-282-1194. Or you can call my 800 number. Either way, my preference would be for folks to call me rather than write me. I have a real important reason for that. If you write me a question, then I'm typically going to respond in writing, and I've got to give you the rule and all of the alternatives to the rule and everything else. So it tends to become this big book I have to write with all the possible outcomes with the whole thing, because I don't necessarily understand what's going on. If you got a quick question, I can kind of usually put it to bed quickly on the phone, or we have free consultations, and people often come in here and ask their questions in that context, because these issues can be very complicated, and folks often want documents reviewed or to have a more detailed conversation than we can do over a quick phone call. But I'm happy to do whatever folks want to do. I'm
Right.
even
Well,
happy to
thank you
sit
for
here
adding
for a
your
second
information.
and answer questions if we want to answer a few questions and stay on long, if that's okay with you.
Yeah, if anyone does have a question offhand that they would like to answer, I didn't see any in the chat. If someone has one, feel free to raise your hand or unmute yourself and ask it now. All right. Well, going once,
It looks like I answered all the
twice.
questions.
I think you did. Well,
All
again,
right,
thank you to all of you who have joined us today. Scott, thank you so much.
no problem.
We hope to see you next month again in our monthly webinars that we'll have. I put our email address for the Caregiver Coalition and our website, so you can reach out to us that way too. And again, thank you for joining us again. We hope to see you at our next month's monthly webinar. See you next time. Thank you so
Absolutely.
much.
Thanks.
Bye-bye.